when you have mother then transferring to this child this inordinate fear, anger, and unwillingness to have an appropriate, normal relationship with his father. So we're dealing with a plaintiff that just cannot accept the fact that dad is going to play a part in her son's life. That's concerning.
Swayam Prakash versus Kamath, case number 23-08759-DM, present in the virtual courtroom. We have both parties as well as their respective attorneys. We're here on the defendant's motion in order to show cause against the plaintiff. I will indicate I have read both the motion as well as the response, and I'm very familiar with this case, having seen these parties pretty frequently recently. And Mr. Young, is there anything else you'd like to say about your motion?
No, Your Honor, other than this is, again, the fourth or fifth time we've had to deal with the same issue, and I'm at a loss as to, how to move forward. And principally, I'm concerned about the minor child and what's going on with the child, and I'm disturbed that based on the answer to the complaint, it indicates that the therapist is no longer going to be providing services to the minor child, apparently based on, what has gone on between the two parties. Dad's just trying to get information, and it's been like very difficult to get cooperation from mom to allow that information to be provided to the dad. So I'm concerned that this child is now not in therapy. I'm concerned that the calls are just not productive. There's the video's turned off. The child is unresponsive. There's clearly, in my mind, a transference of mom's anger and attitude toward dad to the child. That concerns me. So I'm not sure that you can solve that problem as much as maybe getting this child into a therapist, that there is going to be communication and a cooperative a plan put in place for this child being helped.
Okay, thank you. Ms. Nusma?
I want to briefly touch on the therapist, just that the email was sent on the 10th. And I think the timeline is pretty clear that dad reaches out to the therapist, probably copies Mr. Young on the email. The therapist sees what's going on and says, I want nothing to do with that. Mom has reached out to the 3 therapists that were suggested. Obviously, she hasn't scheduled anything. By the time she found out on the 10th, messaged me. By the time I responded, this motion was already filed, so we knew we were going to be here. And at this point, I would hope we could get some guidance from the court on someone who might have the experience in this type of case to not immediately run away. Beyond
Mom's fear and resentment are bleeding into the child experience, making dad look like a stranger in his own son's life.
that, I'm equally at a loss because I told my client to maliciously comply. And by that, I meant provide every single bit of information about the minor child and his treating providers on Our Family Wizard. And that's exactly what she did. I wanted to know what Matthew's shoe size was. And that level of information was provided. We provided releases for the therapist. The one thing I haven't been able to do is draft a blanket release to have my client execute because I don't have the ability to do that. We're here, we're willing to sign these releases and are happy to do it, but we need to know what releases are needed. Beyond that, with the phone calls, the child is 6. And I think at least some of the people in this room have watched a 6-year-old operate a touchscreen in the last couple of years, and a lot of things happen. So if you look at the call logs, you see that the camera's on, the camera's off again. What they've been doing this summer is doing the calls. He sits in the air-conditioned car. Mom stands outside because they're timed, so they happen immediately after he's picked up from camp. She's literally outside of the vehicle. She can't control that. We see some connection issues on both ends. Sometimes dad's video cuts out. Sometimes it's on her end. And you can tell in the log whether it's turned off or it's a connection issue. And nothing I'm seeing shows that anyone's doing this deliberately. Mathieu will turn off the camera for 3 seconds and then it's back on. So I'm kind of we can't, without being present, you can't force a 6-year-old to do anything. Even being present, you really can't. But I'm not sure how to better facilitate these calls beyond that.
If I might respond, Your Honor, we dispute that characterization. Obviously, the court did not allow either party to record these sessions. So all you can rely upon is one party statement that the mom is present. You can hear her in the background. Again, I don't know how we handle that, but clearly, I think one telling email that's attached to the response from June 6th. This is an email from the plaintiff to the therapist in which she relates to the history of counseling with Pine Rest. She indicates that the experience with Pine Rest was negative for Mattia because he was afraid of his father, did not want his father in the counseling sessions, and they were not helpful. That is a lie. I mean, we can get the records from Pine Rest. Those counseling sessions were productive. The child enjoyed the interaction. What we have, though, back last year was mother refusing to accept your order that you had for summer parenting time, filing a appeal to the Court of Appeals or requesting an appeal, emergency hearing because of irreparable harm, that was denied. So we're dealing with a plaintiff that just cannot accept the fact that dad is going to play a part in her son's life. That's concerning. I'm granted, she doesn't want the information. I think if you look at those emails, it's very clear that mom is not wanting to cooperate with what this court's order said. And so that is concerning to me when you have mother then transferring to this child this inordinate fear, anger.
Mom's attorney paints a perfect picture: cooperation, contact, and concern. But the cracks show in the details.
And unwillingness to have an appropriate, normal relationship with his father. And I would
Okay,
say,
Mr. Yang, I'm going to cut you off because Ms. Neosma was actually in the middle of her her response, I think.
You know, I was, but I had pretty much wrapped things up because I think we do need to figure out a different system for the calls. Maybe we do need to allow the parents to record these calls for the next 6 to 8 weeks and see what is actually happening. Because at this point, we have two parents saying two wildly different things. Beyond that, I'm a little curious about where Mr. Young obtained his psychology degree to diagnose the minor child with transference, which is certainly a term of art in the medical field. But this is where we are, that we have a child who does need to get back into therapy. So that's my first order of business, is finding someone. I'm hoping we can do that today and moving on from there. But the larger issue in the past has been providing access to the medical information, and that's been done. So I'm really not sure why we're here on a show cause, because I can't see where my client has definitively violated an order. The allegations were that as of, let me look at my date just so I get it right, as of June 6th, as of June 4th, she hadn't done something that she was ordered to do before June 15th. And so I really don't know why we had a motion filed the day the order entered, that when she'd already complied. Specifically talking about the therapy release, she provided it on June 6th. The deadline was June 15th. Dad's already on the Corewell portal. Dentist and optometrist, I think, are the two that are remaining, and the information's been provided. I don't know that they're going to require anything from dad beyond these orders. And certainly, if I get a release, I'll tell her to sign it. And that's what we've done in the past. But I can't draft one. I don't have the knowledge to put the language in that the medical providers want to see.
All right. I will address the counseling first. I've been adamant throughout this case that this child needs ongoing, consistent counseling. The fact that the parents are in such conflict all the time is definitely felt by this child and internalized by this child. This child probably thinks that this is all his fault or her fault, because this is how children this age respond to this kind of conflict between parents. It's very frustrating to the court that this therapy has been so difficult to get in place and keep in place. And again, it's not surprising that therapists are hesitant to take this case because of the conflict between the parents. So once again, I will indicate that a new therapist needs to be obtained and scheduled at least within 14 days. That there be no disparagement by either parent of the other parent. This is the child's therapist. I don't want to hear that there's been any indication of how it's gone in the past. This is a new page. And if the therapist wants to know how it has gone in the past, the answer should be the court has said, no, you All right.
Do you want to cover the parties being present, that they should be present in the sessions only if the therapist wants them there?
Yes, absolutely. Again, this is the child's therapist. The therapist is in charge. If the therapist wants a party or both.
The judge draws a line. Enough blame, enough delay. The child comes first, period. Therapy is no longer optional. It's court-ordered, essential, and immediate.
Both parties at some point, fine. But certainly initially, parents should not be present.
Might I suggest, Your Honor, that the child was at Pine Rest. I think there was a good therapeutic relationship at Pine Rest. Mom fired that counselor, and it's my understanding that this current therapist has recommended some evaluation. So if we could go back to Pine Rest, they could do an evaluation. They could determine just what's up.
What kind of evaluation was recommended?
She includes it in her last email. It's attached as exhibit to Mom's motion, exhibit 4.
ADHD,
Yeah.
ADHD? Okay.
which
Yeah.
Mom has as well, so we're not shocked.
No, and Pine Rest, I know, does that.
The
So,
one concern that my client's larger concern with Pine Rest is it is a Christian-based organization, and she is not. And so she's not entirely comfortable with that and would prefer something non-secular.
Well, she chose it in the first place. That was her choice.
I understand that, but there aren't that many reputable.
What about Fountain Hill, Ben Burgess? Not Ben necessarily, but someone at Fountain Hill.
I don't know. Do they do ADHD evaluations? I haven't
Let me
heard
ask
that.
Google.
Well, Fountain Hills, in my experience, will cost tens of.
It's
maybe not tens of
expensive.
thousands. It's a very, very expensive. My client is, in between jobs, and look, this has cost him a lot of money, and it has been very stressful on him. So much so that I don't know how much more he is going to be able to try to move the ball up the hill. And so obviously we've got a logistics issue, and
All right. Well, let me get the answer here, Mr. Young.
All right, so it looks like Fountain Hill does, but Dr. Swantrakesh also just suggested there's a location called Headlight Mental Health Care that's, let me see, lasting affordable care tailored to work for you. They do a lot of ADHD work and the evaluations. It looks like it's a larger chain. Probably, as we know, the national companies are buying up the local businesses left and right, and they take
Okay.
their insurance.
Okay. Do you have any connection to that? Does your client have any connection to that company?
Ramya?
Yes, Your Honor, if I may. I did call them and they said that, they could schedule the evaluation as well as the.
Okay, but nobody related to works there, owns it?
No, God, no.
Okay, that's kind of what I was asking. Okay. All right. Sounds good to me.
can we make certain that there is a remote access that my client can participate remotely with whoever the therapist is? I mean, that was
if they yes, and again, I'm leaving that up to the therapist for both parents.
The judge strips back control. Neither parent gets to stall this process any longer.
Well, and at this point, I can't imagine that anyone doesn't have that as an option, given what we've been through in the last 5 years.
Let's just confirm that. I can't imagine either, but let's confirm it before
Did you
signing
discuss
up.
virtual with them at all?
Yes, Your Honor, they did say that they do virtual when needed.
Okay.
And so, Your Honor, if I could just clarify that the therapist would be provided through this, what is the name of the therapy center?
Headlight?
Laura?
It sounded like the evaluation, and then for the therapist, maybe looking at the ones that were recommended by his other therapist. Am I correct about that?
So Headlights would do the evaluation, and then the parties would pick up, or there would be the last therapist made recommendations as to who else might be appropriate.
So we will go with the recommendation of the Headlight evaluator, so that we're not cherry picking who is going to be a therapist to maybe believe my narrative, whether it's mom or dad, because that's the concern.
I understand, Ms. Newsma.
I've been saying headlight because I was reading a chat from my client which had a typo. It is lead light counseling, which makes a lot more sense.
Lead light. Okay. All right.
Because lead light is based in West Michigan, where
Okay. All right. Lead light. All right.
And so I'm clear, Your Honor, you are directing that neither party is going to be talking to these evaluators, therapists, giving their disparaging, experience with the other party. This is a neutral evaluation, a neutral therapy that's going to be provided.
And only providing the basic information, not any opinions about each other.
Very good, Your Honor. And in terms of the ability of my client to then access the therapist and information, my client's frustration was we had a hearing on May 15, which you made very clear what you wanted.
I understand all that, and I will get to that. Those releases, again, I also understand that they don't all use the same release.
Exactly.
So, and it sounds to me like the plaintiff did respond and signed the release within a day or two of being provided with it. And so I can't find her in contempt.
Well, it took 4 emails.
I understand all of that, but that's still a reasonable time to respond. But it's going to be his responsibility to obtain, once she's provided the information regarding the doctor, the school, whatever it might be, counselor, then it's going to be his responsibility.
The court enforces our family wizard. So every excuse now leaves a digital trail. Missed calls and blocked access are no longer dismissed. They're documented.
To obtain, we lost him. Obtain the appropriate release for her to sign. It's not going to be on her, it's going to be on him.
Well, okay, that was my situation when I communicated with Laura. As I told her, he doesn't know who those specific providers are. He doesn't know what their requirement is.
Well, again, that's what I'm required. She's required to give him the information. It's going to be on him to contact them and get that release and get it to her.
And the information is all in our family wizard already.
Yeah.
But the problem was he contacted every individual that she had said was a provider. Those individuals that he contacted, none of them would talk to him. None of them would even send him anything. So what we need, and what I'd ask Laura, is to say, you know who the providers are, just get their release, put his name on it as the father, authorized to receive the information. And I think that is going to streamline this process far more than, I just don't want to have to come back, Your Honor, to get releases when he's not able to. I mean, this therapist, for example, he sent a number of emails to her, and she basically said, no, I can't talk to you. I'm not going to tell you anything. I need releases. Well, Your Honor had ordered her on the 15th of May to give a release, and he's getting an email from the therapist on June 4th saying, I don't have a release and I'm not going to talk to you. So he's frustrated, and I just want him.
I understand. All right, I understand.
But I'm not a secretary.
That's the thing. I mean, I think that providing those providers with a copy of that order and just saying, I need a release. You don't have to talk to me, but you have to give me a release. Give me your form release, your blank release, and he can fill in the information and get it back to them.
Well, she's got to sign it, though.
Yes. Yeah. True. But again, that's what our family wizard is for. I mean, it just shouldn't be this difficult.
Well, and I believe she's set up to do, I know for me, without me using my electronic signature platform, she's got set up for electronic signature. So if he uploads it to the wizard, she can send it back signed.
Yeah. And I can't remember what that order says, but there's a time frame for responding.
Yeah, the Our Family Wizard order is pretty thorough.
Yeah. So whatever that is.
So if she provides specific information through OFW of the address and name of each provider with contact information, you're requesting he then contact the provider and find out what is required by way of a release. If they don't respond to him, can I have alternatively that
Yes,
she,
yes. Then he needs to let her know with, the proof that she needs to obtain the release because they're just not communicating with him. And then
Okay.
I'll shift the burden at that point.
Yeah, I just want a solution, and I want this child to be able to, have a functional, productive relationship with dad, and it's not there right now.
Okay.
And if it helps, if you want to send discovery subpoenas requesting the form, even though there's not a motion filed, I'm not going to object and throw a fit about it if that gets the forms faster.
All right.
I don't know why when she's in there, she just can't get a release form that she could then send to him through OFW. That's all.
And to the extent that can happen, that'd be great if it
Which
keeps
is what
everybody
did with
from
the
this.
therapist.
All right. And as far as the parenting time and the video, I get, especially my understanding is she's in the car right now, or he's in the car at camp and all of that. So there's some connection issues. But I do think, I don't like to do this, but I think given the allegations, I think they do need to be recorded.
Will our family wizard do that?
I think so.
Okay.
Yeah, I think so.
I like that just because it kind of takes both of them out of it.
Yeah. But again, it's not something that I want to continue forever and ever because there really should be private conversations between dad and the child.
Yes.
But-
And so they have to have the max package, but she can record.
Okay. All right. Is there anything else?
Well, Your Honor, this is not part of the motion, but we had some parenting time scheduled for July that, due to a unavoidable work reassignment, my client is not able to make that trip. So I don't know, we're not asking for it, but we would like possibly a week and maybe the Christmas break for him to be able to see the child. I know that's not in the current parenting time order, but if the judge could give maybe some sense of its position on.
I think that would be appropriate.
Yeah, and talk to me. I don't know what she's got planned. So
We've got plenty of time at this point
Yeah.
for, I think, council to discuss it. But yeah, I'll just indicate that I think that would be a good idea.
Thank you.
Okay.
Okay, and so you're not awarding any cost at this point? Could that be reserved in the event that there's some issue that comes up in the future? Because quite frankly, I'm not hopeful, but I'm going to
I
try.
understand, but the burden of proof for contempt is on the person bringing the motion, and I don't think it's met. I think there's too many factual questions here, as well as some ambiguity. I hope I've clarified that now, and it's clear. And so in the future, this court will definitely enforce it.
Thank you. I will prepare that order.
All right. Thank you.
Thank you.
The court didn't find contempt, but this is Mom's final warning. Follow orders or face consequences. Orders are tight. Instructions are clear. This is the court's last olive branch.